In today's update, a dramatic twist in the long-running trial of Nnamdi Kanu, the leader of the proscribed indigenous people of Biafra IPOB. Kanu has now declined to open his defense in the terrorism charges brought against him by the federal government, insisting that there is no valid case to answer.
Where's the lying news agency of Nigeria? Are they here? Those liars and deceivers, are they here? That distort the news. You don't know what law is. You don't know what justice is. Where's the news agency of Nigeria? What are they? You don't know that God is a God of justice. You don't know that? That God in heaven is a God of justice. You don't know that?
But that's what you wrote. You said here, my lord, that the defendant has now applied for bail. Now, as I've said earlier, bail is a decision of the court, taking into consideration all the conditions laid down in Muhammad Abacha v. State. At this stage, I am of the opinion that to make or take a stand on the bail application without first hearing and determine the issue that is glaring in the face, which is the absence of the defendant from the court since 25th of April 2017 until he was produced on the 29th of June, my lord, which was exactly what the Supreme Court did. They said that he did not jump bail. These criminals came to my house to kill me. That's what the Supreme Court said. This is in your own court, my lord. So I cannot understand, my lord, why my trial will be conducted contrary to the Constitution of Nigeria that said I must have free and unfettered access to my counsel. Is here. Okay. He did something in my case. I refused him. He was something official. I asked him to recuse himself. Why did the chief judge insist I must write? He left my case.
Okay, listen. If anybody is not happy with this, which is you, then you need to go and
No, I cannot. Because I have a court order. I have a court order. You have refused yourself. I have a court order. Anybody who disagrees with this order of court, go to appeal court. That's what you tell me all the time. You are from this official. You cannot preside over this case number again. Not in this life. You cannot. Not now, not tomorrow, not ever. A woman here cannot force this court to preside on my case. You cannot. Not today, not till forever. You are recused and you stand recused. Tell the chief judge, Nnamdi Kanu said, go on appeal. I recused him from my case. The state recused Justice Adema from my case. I did not insist Adema must hear my case. I never insisted. So why must you insist to hear my case? I don't want you in my case. I don't need you in my case. You are biased. You are biased if you are not in my case. A woman should do the right thing. A chairman of the board of managers responsibility shall resume propriety. Nowhere in the world such nonsense talk. You cannot be hobnobbing with lawyers, hobnobbing with justices, and you're proceeding a case. It's shameful. Absolutely shameful. Shameful. This is not a court of law. This is a shrine to injustice. And I will not subject myself to it. You stand recused and you must take my case. You cannot write me.
I'm the second time I wrote it. I simply applied for a legal trial of the defendant.
This man is not paying attention. There is an order of recusal. And he's a senior advocate, for goodness sake. There's an order of recusal. Is that not the rule of law? The law says if you disagree with this, you go and appeal. You are a grown-up man. Because of 300 million, you're behaving like a child. Go and appeal. Because of money. Because of money they're paying you from ATM surface, you are here standing and smoking evil. Because of money. A grown-up man like you say you have to behave like a man of honor. The rule of law says you go and appeal. His Lordship Peter, you go and try my case. Not on this planet Earth, I'm telling you that now. So stop wasting your time.
So that, as I said, the view of the past, that the defendant has indicated that he will not make a formal application. I advise that the authority was a safety day for hearing.
You are not well. You are not well. I'm telling you, this God Almighty not well. This is an order of God. An order of God says, Justice Binta Nyako is recused. An order of God. Order she made as an order. The same Chief Justice writing the stupid memo he's writing. I recused him. He was functus official. He sat on appeal. I took him to the NJC. I recused him. Why did he not say I must sit on your case? Why in the case of his lordship is he insisting? He wants to embarrass her. He wants to embarrass your lordship by asking her to come and sit on this case. Is that what you're saying?
Please,
There's an order. Give it to him. He doesn't have it. Give him an order of court. It's an order of court. Give it to him. He doesn't have it. An order. Give it. He doesn't have it. It's an order of court.
I take your permission.
It's an order of court.
I take your permission to address you. But let me tell the defendants that in every sin life, there's need for wisdom. And wisdom is very important in this matter.
And telling lies.
It is not right for you to be insulting the teacher and insulting.
If you insult yourself, I will insult you. If you have no respect for yourself, I will insult you. Because people are telling the law, when it comes to Nnamdi Kanu, you turn the law upside down. The law says one thing. If the law says this paper is white, when I go to court, they say it's black. When I say it's black, they say it's white. Is that law? I'm asking you, a senior advocate of Nigeria, is that law? Is the memo from Chief Judge, is memo from Chief Judge sufficient to set aside and a court order? The answer is no. Why do you want to change the law in my own case? His Lordship, Justice Binta Nyako, stand recused in my case. Cannot try me. Why don't you get it? Give me your definite get for trial so you can do your mathematics you always do. People without shame. I have here before me for the benefit of Chief Awomolo because it seems he doesn't know the law. So I will tell him, this is national judicial policy of this country. Please give them a copy each. National judicial policy of Nigeria, national judicial policy. I will tell you what it says. Because you don't know, I will tell you. Talking about memo from the Chief Judge of the High Court. Judicial policy of Nigeria, 1C. I'm reading. Verbatim. In the performance of judicial functions, the judge is subject only to the law and must only consider the law. The rule of law in every common law jurisdiction in the world is that once an order of court is entered, the only way to set it aside is by going on appeal. That's the rule of law. You're a senior advocate, you don't know. I will go to see. A judge must not take or attempt to take orders or instructions of any kind from anyone, even the chief judge, from anybody that may influence his decisions in the performance of judicial function. It means that his lordship, having entered an order of court, a decision.
Hello everyone, and welcome back to Trending Nigeria. I'm Hadenuga Progress. In today's update, a dramatic twist in the long-running trial of Nnamdi Kanu, the leader of the prescribed indigenous people of Biafra IPOB. Kanu has now declined to open his defense in the terrorism charges brought against him by the federal government, insisting that there is no valid case to answer. At the Federal High Court in Abuja, proceedings took a surprising turn on Monday, October 27th, as Kanu, who had earlier indicated plans to call witnesses in his defense, suddenly changed course. You all recalled that the court had adjourned on October 24th to allow the IPOB leader time to open his defense following his application for witness summons and a request for more time to study his case file. But during today's resumed hearing, Kanu told the presiding judge, Justice James Omotosho, that after carefully reviewing his case, he has realized there is, in his words, no valid charge against me. He argued that since the charges are, according to him, invalid and unconstitutional, there is no need for him to call any witnesses or enter any form of defense. Justice Omotosho, however, advised the IPOB leader to seek expert legal advice on the implications of his decision. The judge noted that declining to open a defense could have significant consequences under Nigeria's criminal law, especially since the prosecution has already presented its evidence. He then directed Kanu to file a formal written address stating his position and to serve it on the federal government's legal team. Justice Omotosho further adjourned the case till the 4th, 5th, and 6th of November for the adoption of final written addresses at the session. The court is expected to determine whether the prosecution has established a prima facie case against Kanu, or if the defendant's argument of no case submission will stand. This development marks yet another chapter in the long and complex legal battle between Nnamdi Kanu and the Nigerian government. Kanu has faced multiple counts of terrorism and other related offences charges which he and his legal team have consistently described as politically motivated and baseless. Since his rearrest and extradition from Kenya in 2021, his trial has sparked intense debate both within and outside Nigeria, particularly among his supporters who continue to call for his release. Legal experts say the next hearing will be crucial. If the court agrees that the prosecution has failed to establish a case, it could potentially mark a major turning point and possibly lead to Kanu's discharge. However, if the court finds otherwise, the IPOB leader may still have to open his defense formally. For now, all eyes are on the Federal High Court in Abuja as Nigerians await the outcome of this high-profile trial, one that continues to stir political, legal, and emotional reactions across the country. That's it for now on this developing story. Don't forget to like, share, and subscribe for more verified updates on Nigeria's political and legal landscape. I'm Hadenuga Progress, reporting for Trending Nigeria. Thanks for watching and see you in our next update.